House Republicans are expected to push a vote today to censure Intelligence Committee Chairman Adam Schiff. Now, Schiff has become a central figure in the impeachment inquiry.
Republican lawmakers say they aren't happy about how he's handling it. Any action on a censure would be largely symbolic. CBS News legal analyst Kim Wehle joins us now from Washington to talk about the latest in the impeachment inquiry. So, Kim, you are probably aware that we spoke with Paula Reed at the top of the hour about the drama surrounding Acting Chief of Staff Mick Mulvaney's acknowledgement of a quid pro quo and the subsequent walking back of those comments, essentially trying to say he
walking back, but not really changing.
Not changing. Well, he can change it if he wants, but he's on tape for essentially admitting that there was a quid pro quo. So what significance do those remarks have? I mean, what significance does the walk back have, I guess, if you're a lawyer and you're trying to weigh the two?
Well, the significance of the walk back isn't much. If this were a witness that was going to be called in a judicial proceeding, he would easily be impeached if he were to walk it back on the stand by showing his candid comments, his off-the-cuff comments, which some people would read as being more credible, the ones that he made in the moment, not the ones that he made after he presumably got pushback from his boss. But the issue here really, as you know, has to do with the politics of it. Senator Lindsey Graham has said recently, stunningly, that if there was an actual crime involved here, if there's evidence of a crime, he might actually be inclined to consider impeachment of this president. And it's the quid pro quo piece that potentially could bring this to a level of a crime as a matter of sort of common law and federal law, in that extortion and bribery requires some kind of an exchange. Of course, impeachment itself does not. The president could be impeached just by abusing office, even if it wasn't in exchange for something like getting adverse criminal investigation activity on a political opponent. But it is significant that his own chief of staff is essentially validating that narrative that is quite damaging. And then it really comes down to whether the populace and the Republicans in the Senate care enough about the rule of law and the integrity of the office to draw the line here.
So you have a new article out in The Atlantic, and it's about how the lines have blurred between the role of government lawyers and the role of the president's personal lawyers. And you actually go all the way back to the State Department. You talk about the AG, Bill Barr, releasing that summary of the Mueller report before the Mueller report came out, letting everyone know that there was no collusion, which was not what the Mueller report said. And then you kind of follow the line all the way through to the president's personal attorney, Rudy Giuliani, conducting, like, according to State Department employees, conducting his own sort of shadow foreign policy in Ukraine. Can you walk us through this?
Yeah, I mean, as you know, I'm also a full-time law professor, and this is really, and I've been in the government, so this is really serious stuff. There are two things to keep in mind. One is that there is a legal and ethical line that lawyers can cross in terms of making legal arguments. So Mr. Barr saying that there was no collusion, that's arguably an ethical line. He has an obligation to the American public to tell the law accurately, and conspiracy is really different from collusion. Collusion's not a legal concept. So that was really a political statement. And I would argue ethically he has an obligation to the American public to be extremely accurate, because it's really the American public that is the client here for Mr. Barr, not the president. The other piece has to do with who your client is. I mean, I worked inside the Justice Department. I've worked for private sector clients. And there is a difference. When you work for a private sector client, the question is, how can we win on behalf of our clients within the legal and ethical boundaries? When you work inside the federal government, the question is a little bit different. It's how does this play out over the years for purposes of the integrity of the legal system and our bigger client, which is the United States population and the United States of America itself. And in making arguments, not only Mr. Barr, but later the Justice Department withholding the whistleblower complaint, making a really, I think, a very tortured argument that the statute allowed the Justice Department to keep the whistleblower complaint back, when the statute clearly said that whistleblower complaint shall go to the Congress under those particular circumstances. And most recently, White House counsel, Mr. Cipollone, arguing that due process basically protects the president from a House impeachment process, and that impeachment itself is somehow unconstitutional. These are not only, I think, crossing the line legally. If they were filed in court, there would be a rule called Rule 11 of the Federal Rules of Civil Procedure procedure that could sanction arguments that are so off the mark that they could be frivolous, and arguing that impeachment itself is unconstitutional is really frivolous. But also it blurs who the client is, and that's a really important consideration. And government lawyers understand, if they're validly executing their office, that their client isn't Donald Trump, the person. The client is the office. And this is something I think we need to keep our eye on, not only in terms of what's happening inside the White House today, but also to preserve the legitimacy of government lawyers in the Justice Department and the White House counsel's office in the eyes of the public.
Kim, I have two questions before we let you go. One real short one, and then one that maybe you could take some time to explain. The first is, I guess, you've heard repeatedly folks say that the whistleblower needs to be unmasked. And I'm trying to understand, just from a legal standpoint, I thought whistleblowers generally, when they come forward, they merit anonymity because of the things that they are coming to share with the American people. So you got a lot of Republicans that are saying that the whistleblower should be unmasked, ranging from the president of the United States saying he wants to know who the whistleblower is to others. I just wonder if you can briefly address that. And then I just want your take on the Department of Justice coming out with this unusual statement saying that they would not have met with President Trump's personal lawyer, Rudy Giuliani, if they had known his associates were under investigation. That's kind of unusual coming from the DOJ.
Well, I mean, so number one, the whistleblower law actually predates the United States Constitution itself. The Continental Congress, prior to ratification of the Constitution, passed a law basically protecting whistleblowers. And so it's the idea that this whistleblower should be unmasked basically uproots completely the whistleblower law itself. We need to have, as Americans, people inside government that can let us know when things are going awry. Otherwise, stuff happens that can be deeply damaging, and there's no scrutiny of it. And it's also not realistic because right now the issue is, what is Congress uncovering with witnesses in that impeachment process? What the whistleblower put in the complaint is beside the point. Now the baton has been handed off to Congress, and that's where everyone's eyes should be, on direct evidence of wrongdoing here. With respect to the reports that the Justice Department was unaware of what Mr. Giuliani was doing or whether there's investigations, that is puzzling. People need to keep in mind that, of course, Bill Barr is at the apex of the entire United States Justice Department. That is, anything that happens in the various U.S. attorneys' offices across the country, all of those people ultimately answer to Mr. Barr. That doesn't mean that he knows, he has firsthand knowledge of each decision that each prosecutorial arm is making. That said, the president's personal lawyer being under investigation, potentially in the Southern District of New York, that is something of such political sensitivity that probably would go, no doubt, to the Attorney General, which I think, in one hand, the fact that that investigation's going on should give us all comfort that the Justice Department is continuing to operate in an apolitical manner. But as I note in my Atlantic piece, the other problem is we're seeing a blurred line between government lawyers and personal lawyers. In the Whitewater investigation, Mr. Clinton had an army of personal lawyers that were paid not by taxpayer dollars, at least to some degree. If you're a target of investigation, you can be reimbursed. But there were personal lawyers who have a different ethical obligation to their client than, as I said, government lawyers. So Bill Barr's ethical obligation is different than Rudy Giuliani's ethical obligation, and that blurring is problematic.
I love how passionate Kim is about constitutional law.
Yes, that's why she has a book called The Constitution and How to Read It.
Yes, you should check it out. Kim, thanks you so much, Kim.
Thank you.